Good morning, everyone. I hope your day is going well. Thank you so much for engaging in today's presentation. Just to give a rundown of how today's presentation will go, I'm going to open up and discuss the role of the FNE. I will then hand it off to Grace Rupp, who is our PREA and SART policy specialist, who will be presenting the role of law enforcement. And then she will turn it over to Tiffany, who is a Sexual Assault Legal Institute attorney who will be presenting the role of the prosecutor, and then we will go ahead and go into our sexual assault response team panel. So once again, thank you so much for engaging in today's presentation. As I said, my name is Natalie Scott. I'm MCASA's Sexual Assault Response Team and Sexual Assault Forensic Exam Policy Advocate. I'm going to start off today's presentation by presenting the role of the Forensic Nurse Examiner, also known as the FNE. If you have any questions that come about during this portion of the presentation, please feel free to drop them in the chat or any additional comments, and I or another MCASA staff member will try to answer them or address your comment or concern. And also, just as a personal note, I am fighting a head cold right now, so if my voice randomly cuts in and out and gets raspy, I apologize about that as well. So we'll go ahead and move on. So to start out, we're going to discuss what a sexual assault forensic exam is. So a sexual assault forensic exam a SAFE stands for a sexual assault forensic exam. And it's a procedure that provides survivors with important medical care, and allows for the collection and preservation of potential evidence from a sexual assault. So I find the easiest way to break down and understand a SAFE is to separate it into two parts. The first being medical attention, and the latter being evidence collection. The medical attention portion includes elements such as checking and treating for potential injuries, providing STI prevention, treatment and or testing, and then also pregnancy prevention. So, for example, providing emergency contraception pills like Plan B. Evidence collection, or the evidence collection portion, includes taking photos of injuries, the collection of DNA, and the collection of clothing items. It is important to note that new laws state that sexual assault forensic exams conducted up to 15 days after the assault will be reimbursed, and they will be provided, financially provided by the government. So the new law does not, however, specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. But I do want to mention and just emphasize that SAFEs can be completed up to 15 days after an assault. So when understanding the process of receiving a sexual assault forensic exam and reporting sexual assaults, it's important to understand the different options for survivors. So survivors have options when choosing to report a sexual assault, either to the emergency department, to law enforcement, or to a rape crisis center advocate. Survivors reporting to the emergency department may choose not to receive the SAFE and just simply receive medical treatment. If they choose not to receive a SAFE, advocate presence should still be offered, since they are still survivors of sexual assault and still should have access to those services. I also want to add that child protective services and adult protective services should be called in cases that involve child sexual abuse or cases that involve vulnerable adults. When I was first learning about this, I wanted to develop a better understanding of who was considered a vulnerable adult. So vulnerable adults, according to Maryland's Office of the Attorney General, are people over the age of 18 who lack the physical or mental capacity to provide for their daily needs. So moving on to advocacy. So advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including in the exam room. Before an exam, advocates can work to address acute concerns identified by the survivor, work through any questions they have about the exam process, explain their role and services, and review potential reporting options. During the exam, advocates can help support the survivor through any and all parts of the exam, including offering grounding strategies, co-regulating, offering encouragement, and empowering the survivor to choose from the menu of exam options. It's important to be aware of what to do if you're in the exam room. So, for example, don't speak for the survivor, don't touch nursing tools. It's overall just important to understand your physical place and space in the room itself. It's also important to be prepared to ask a survivor if they would like privacy or for you to stay during various parts of the exam. So, for example, some survivors want your physical presence during the narrative portion of the exam, but may request privacy during the speculum exam or evidence collection. So, just being aware of the survivor's wishes and respecting when they would like your presence and when they would prefer privacy. After the exam, advocates can work on a safety plan for the post-crisis intervention period by connecting survivors with ongoing advocacy and community referrals and address ongoing concerns. The sexual assault forensic exam hospital or the hospital that houses the sexual assault forensic exam program should have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. Advocates can work with forensic nurse examiners and potentially law enforcement to ensure a timely, survivor-centered, coordinated response to the hospital. I do want to note a survivor may choose to have an advocate at the hospital, even if they choose not to have a safe completed. I know we mentioned that earlier, but just to kind of reiterate that point. And then survivors are not required to have an advocate present and they may choose not to. In this situation, an advocate can provide contact information or other relevant community referrals for the survivor to reach out if they want to in the future. So, respecting the survivor's wishes, but keeping the line of communication open should they like to receive services in the future. So now we're going to go in depth to understand exactly what occurs during a SAFE or a sexual assault forensic exam. So a SAFE includes several important elements, including a detailed interview by a forensic nurse examiner, a body exam, evidence collection, photographs, and a documentation of findings. It's important to note that a survivor can choose not to receive any portion of the exam at any time. During the interview, survivors can disclose what they choose about the assault. However, an advocate can gently encourage details. This is because that narrative will impact medical prescriptions and evidence collection. And then I also want to note the time frame of the exam. So the exam can last anywhere between 3 to 6 hours. So it can be a lengthy process. So during the exam, the F&E will look for bruising, wounds, and other injuries that may have occurred during the assault. If any injuries are present, the F&E will use photos to document the wounded areas. You can see some examples of this in the photos on the slide. There are also cases where injuries are not visible. So, for example, I think the most prominent example of this is strangulation cases. In these instances, an alternate light source, or ALS, may be used to photograph the area. So you can see an example of that on the slide as well. An alternate light source, or ALS, is a technique that can detect bruising or injury that has occurred beneath the skin layer and is not available to the naked eye. So I just wanted to touch on that as well. So a forensic nurse will use cotton swabs to collect evidence from various parts of the body. This is bringing us to our next topic, which is swabbing. So they will use cotton swabs to collect evidence from the skin, inside the mouth, under the fingernails, A genital and anal exam are also completed, in which a forensic nurse conducts both internal and external swabs of the area. Um, the areas are swabbed based on the victim's narrative of the assault provided to the FNE. This is why providing details may be especially important, as it can guide evidence collection and increase the likelihood of obtaining DNA. As an advocate, I do want to mention one should never speak for the survivor or force them to provide more details than they are willing. However, supporting them during the process and helping explain why it's important to provide those details can be very beneficial. So once again, gently encouraging those details to provide evidence collection, but not forcing it upon the survivor, and not speaking for the survivor as well. Finding that balance. Moving on, we're going to discuss post-exam. So it's important to mention that sexual assault forensic exams are offered to survivors of sexual assault free of cost, with or without insurance, as they are government funded. The FNE or advocate will inform the survivor about community resources available to them, including counseling or support groups. The survivor will also be offered, as mentioned before, emergency contraception such as Plan B, and then also STI treatment and prevention, so STI prophylaxis or HIV prophylaxis, free of cost. The exam, once again, is free regardless of whether or not the survivor chooses to report to law enforcement. So in those cases, the evidence collection would be stored anonymously if the survivor chooses not to involve law enforcement. Now discussing evidence preservation. So there are several things a survivor can do to best preserve evidence before getting a sexual assault forensic exam. So, for example, not changing clothes is important because the survivor's clothes will be collected into evidence during the sexual assault forensic exam and put into a sexual assault evidence kit. But I do want to mention if the survivor does change clothes, they can bring the clothes that they were wearing during the assault with them to the hospital to be collected if they are available to them. I also want to note it's advised that survivors refrain from using the bathroom, eating, drinking, or brushing their teeth. And then in addition to that, it's advised to refrain from using the shower or bath beforehand in terms of evidence preservation. But I always like to emphasize that if a survivor has done any of the previous listed activities, do not discourage them from getting a sexual assault forensic exam, as it's still possible, and the FNE will still attempt to collect evidence. So that is all I have on this portion of the presentation. I'm going to go ahead and hand it over to Grace Rupp, who is going to present on the role of law enforcement. Thank you so much.
Thanks, Natalie. I am going to just quickly.
Hey, Natalie, just before we go into the next presentation, I saw a question in the chat for you. The question says, is there a good guide to what parts of the SAFE correspond or for? For example, I have assumptions about why they swab under the nails, but I don't know why.
So there's actually a practicum that was posted by I think it's IFN, and I can share it with participants after the panel that kind of walks through, it's a virtual practicum that walks through a SAFE and what FNEs do and why they do them. It's free of cost if you're ever interested in viewing that and walking through it. I've done it myself just because I was curious to see more about that information. So if you'd like to learn more about the why, I can share that with you all if you're interested. Perfect.
Hello, everybody. My name is Grace Rupp. I am MCASA's Sexual Assault Response Team and Prison Rape Elimination Act Policy Specialist. I use she and her pronouns, and I'm really happy to be here with you today. So today we're going to focus on the role of law enforcement and how they collaborate with victim advocates to best serve survivors. Full disclosure, I am not a law enforcement officer. I have never been one. I don't have lived experience in doing the work of law enforcement, but I have served as a victim advocate and worked closely with law enforcement. this is really just going to be a high level of how law enforcement officers might engage with survivors. All right, so quickly, our goals and objectives for this session is just to review how law enforcement might receive and respond to a report of sexual assault. We're going to review the role of law enforcement regarding the interview process and any sort of evidence collection. And then lastly, we really want to understand the role of victim advocates during the investigation and working with law enforcement. So thinking about how law enforcement might receive a report of sexual assault, there are several ways that they might get that information. First is through hospital personnel. And this does require explicit survivor consent before contacting law enforcement. When a survivor arrives at a hospital, they are given the option to inform law enforcement and report the assault, but they are not obligated to. This does not impact their right to a free sexual assault forensic exam. If a survivor would like to involve law enforcement, the hospital personnel, typically emergency department staff, will contact the local law enforcement agency for them to respond to the hospital and eventually interview them. Again, this requires explicit survivor consent. The survivor may contact law enforcement directly. They may report immediately after the assault, potentially while violence is occurring, and they may delay report. A delayed report involves waiting to contact law enforcement with a time gap. This gap can be potentially days, weeks, or years after the assault. Law enforcement will take that report and investigate. They might also receive reports of sexual violence from a third party or witness. Just as a gentle reminder, with third party reporting, law enforcement is typically somewhat limited in how they can investigate, except in certain circumstances. So Natalie mentioned with vulnerable adults or child protective services, they have a little bit more leeway in investigating that. But law enforcement cannot force a survivor to engage in any sort of criminal justice system or any sort of investigation. Typically, in most cases, a patrol officer is the first responder to meet with a survivor, and then a detective would be called to the scene. So what are the responsibilities of law enforcement? What are they obligated to do? First and foremost, they have to initially respond to the survivor. So we want to work on identifying the survivor's needs and laying the groundwork for positive future interactions with the survivor. So first, they have to speak to the survivor to determine what happened. This typically initially starts that relationship and starts that rapport building. Then they need to assess for the need for emergency medical care and support them and or encourage them in accessing a sexual assault forensic exam. So again, as Natalie mentioned, SAFEs can be conducted up to 15 days post-assault, and really prioritizing that medical care piece and that physical safety piece. Again, thinking about addressing safety, medical care, physical and mental well-being, and then working through that. From there, they might be working then to collect information to identify and locate the suspect. It's important for law enforcement here to speak with compassion and create rapport with the survivor. Typically, they're using interviewing techniques such as forensic experiential trauma interviewing, which Natalie and I will go over tomorrow. But that really focuses on that compassion, empathy, building rapport, and that really helps survivors to continue to participate in the process. From there, they'll begin that sort of preliminary investigation. Responding officers will have to decide whether they need to make that immediate arrest. This decision is made on factors around probable cause, whether that perpetrator is an immediate threat to the rest of the community, things like that. And then lastly, they'll work on securing and investigating the crime scene. So first and foremost, we want to work on protecting that victim. So gathering that preliminary intervention tends to be secondary, and then protecting the crime scenes and collecting relevant evidence. It's important that when law enforcement is doing this work, they're being trauma informed. And part of that can include working with a victim advocate. Most law enforcement agencies work with their local rape crisis centers who can provide more tangible emotional support. And they can work together to include and complete tasks like safety planning, meeting basic needs, supporting survivors in accessing medical care, and then thinking about maybe some of those more ongoing case management or needs-based assessments. All investigators should be trained on trauma-informed interviewing techniques and being mindful of the impacts of trauma on survivors. Natalie and I, again, will go into more tangibles tomorrow around what some of those impacts might look like in real time. Gathering that initial information can be really challenging with what we know around the neurobiology of trauma. Recognizing these effects of trauma and the use of appropriate interviewing techniques can really help support successful investigation, but also the long-term healing and wellness for a survivor. Law enforcement should also be aware that survivors may experience symptoms of trauma that affect their ability to recall information, especially in a chronological manner. So this sort of if, then this happened, that can be really challenging. Additionally, survivors may experience a wide range of emotions, anywhere from hyperactivity to flat affect, those shock symptoms, depression, anxiety, anger. It's important that all parties, including victim advocates, recognize that there's no correct or right emotion to have or to display after a sexual assault. So moving on to the investigation piece, we went over the responsibilities, those initial ones, but what does it look like when law enforcement starts to investigate? So first and foremost, they want to be prioritizing the safety of the victim and or secondary victims, typically family members or loved ones. They want to be looking into whether the suspect is known or a stranger, and that includes asking the survivors for details. As a victim advocate, you might be present for some of these questions. Some of these questions may unintentionally sound victim blaming, i.e., what were you wearing at the time of the assault? It's important to be able to translate these questions for survivors. So providing background and context can help avoid or mitigate some of those re-traumatizing questions and develop some understanding around all parts. So you might say something like, the law enforcement officer is asking you this because he might want to collect your clothes as part of the investigation. He's not blaming you for what you were wearing. Some of that why can be really helpful for survivors. Law enforcement is also responsible for continuing that investigation, but it's important that they prioritize the ongoing safety of the survivor and the family. Addressing safety, ensuring safety to the best of our abilities can ensure that survivors feel comfortable to continue to engage in the investigation process. As an advocate, safety is also something that you should be continuously prioritizing and evaluating with proper safety planning. So really thinking about safety planning and safety in general as an ongoing discussion. And that looks different survivor to survivor. Remember, there is this belief that sexual violence are typically perpetrated by strangers, but we know that roughly 75% sexual violence is committed by someone known to the individual. Knowing if the offender is a stranger or someone known can be essential in determining next steps for an investigation. Stranger sexual violence may require the survivor to participate in a more detailed interview immediately, as there may be a threat to the wider community. In the case of a known offender, law enforcement may be able to obtain basic information that will allow the investigation to begin, while also giving the survivor space to rest and recover. Some items that might be important for law enforcement to get a hold of immediately or address immediately might be things like weapons. So was a weapon used? Where is it now? Really, again, prioritizing that safety piece. They might ask additional questions around the use of force or physical threat, and then questions around the involvement of drugs and alcohol. Typically, these details are essential to a criminal and justice investigation and the prosecution of cases. With all of these details, law enforcement can then determine if there's the ability for a search and seizure warrant. And then, as Natalie mentioned, of course, there's a sexual assault evidence kit, which would include forensic analysis. So the evidence piece, what type of evidence would law enforcement be looking for? How do they manage it? What does that look like? So there are multiple types of evidence that law enforcement might be looking for, but the primary one is typically the sexual assault evidence kit. Survivors have the right to that free exam 15 days post-assault. Law enforcement does store the SAKE, is the acronym, along with other evidence from the crime scene. These are all things that they may be looking into as it relates to physical evidence. So some of those things might include materials from the scene, pillowcases, blankets, other items that might be in the room, victim clothing, so undergarments, any other sort of things that they might have been wearing. Body fluids, they might be looking for things like condoms, other forms of contraception that were used, digital imagery if that exists, cell phone communications, any engagement on social media or online can also be helpful in that evidence collection process. Of course, this list is not at all exhaustive. I don't mean it to be just a few key examples that you might see that may be collected. Details provided by the survivor, the offender, any sort of witnesses during investigations may guide the collection of additional types of evidence. So for example, the sexual assault took place at a party. The information provided by the survivor and witnesses would guide what evidence law enforcement would collect. So in this case, if there's a concern about drug-facilitated sexual assault, law enforcement might collect any of the cups or alcohol at that party. So the information that participants provide to law enforcement guide evidence collection. I do just want to highlight anonymous reporting. This is really important for victim advocates to know and understand. Survivors do not have to report to law enforcement. They have the right to what's called an anonymous exam. Survivors have the ability to have their sexual assault evidence kit collected, but not report to law enforcement, and they can still get that free exam. This means that there's no official police report until the survivor chooses to initiate one. However, the kit will be stored with law enforcement. There's no personally identifying information on an anonymous kit. They have no information about the survivor until that survivor decides to report or initiate that report. Those anonymous kits will be held for a minimum of 20 years in Maryland until a survivor comes forward prompting that reporting and that investigation. That kit will be held. So at that time, once a survivor reports, that law enforcement would open that kit, gather any information and details around the assault. Until then, that kit is simply stored. Jane Doe or anonymous Jane John Doe or anonymous kits allow survivors to receive medical care and forensic evidence collection without reporting to law enforcement immediately. So that offers survivors, time to receive care and time and space to think and heal before engaging with law enforcement. It gives them time to recover after the assault before reporting, and survivors can always convert their kits from anonymous to reported. This type of reporting can keep victims from dropping out of the criminal justice system entirely, which may happen if they report before they're emotionally ready to do so. Remember, it's the survivor's decision on whether they report to law enforcement or not. We really want to avoid incorporating our personal opinion into their decision-making process. Let them know that whatever they decide is absolutely okay, and your engagement with them doesn't stop if they decide to report or not. Encourage them to do what's best for them, and just let them know that you want them to make an informed decision. So what do advocates do while working alongside law enforcement? What does that look like in real time? So first and foremost, we are there for unconditional support of the survivor. The role of the advocate during an investigation is all about the survivor. If you're involved in the interview process, you want to ask what their needs are. Inform them of their rights, so things like crime victims' rights attorneys, access to medical care, etc. You want to think about making those relevant referrals and well-timed referrals, and then encouraging those basic self-care practices, supporting their safety emotionally and physically. Advocates can provide support and accompaniment during an exam or an interview. We really want to focus on being that calming and grounding presence, checking in with their emotional state, providing reassurance and validation. That can look like asking if they need a break, asking if they need food or water, being mindful of staying regulated as an advocate. Natalie went over some of those safe recommendations, so avoiding drinking or eating or showering, reminding them that if they did those things, it's still perfectly okay to get a safe. And then finally, I know this can be really difficult, but it's absolutely okay to sit in silence with the survivor. We don't always have to fill the space with talking. Really being that calming, regulated presence is invaluable. Your presence alone may be the only support a survivor wants or needs while they process the trauma they have experienced. Additionally, it's appropriate for advocates to remind survivors of their rights during the process. This includes getting their sexual assault evidence kit tested, their ongoing engagement with law enforcement, and access to other referrals. During an interview, it is appropriate to remind victims that they can ask for breaks or ask questions if they need clarification. Keep in mind, though, that it's best practice. We don't interrupt survivors, we don't speak over them, but we do hold space for them and create space for them. So just to finish it off, advocates are providing that emotional support. They're advocating for the survivor's wishes, not their own. They're assisting with that safety planning piece. We'll go over safety planning in more tangible ways. And then they'll be helping with other referrals. So counseling, case management, legal, any other things like that. And just some things to avoid as an advocate. I know that sounds very negative, but again, our agenda is the survivor's agenda. We are not here to encourage or discourage survivors from reporting to the police. We are here to encourage them to make informed choices that are best for them. Just a gentle reminder that not all survivors will want to engage with law enforcement, and our support for them is not contingent upon their engagement with law enforcement. And then lastly, it's not our job to interview survivors. We don't need to ask those W sort of questions. We want to be there as a source of support and safety. It's not our job to investigate. I always think about asking sort of neutral questions if survivors seem dysregulated or maybe like they're not understanding. So things like, would you like the nurse or officer to explain that again? Can you use different words to explain that to the survivor? We want to think about using those prompts when they're helpful and relevant. But again, addressing that communication piece. I know this can be difficult, but we don't want to make promises or assumptions about any sort of investigation. So don't make promises or say things that aren't true and you can't confirm with 100% accuracy. So we don't want to say things like the police will get them, this person will go to jail. We can't guarantee that. As such, we should not say that. Finally, we really want to think about, suspects may not get arrested. And even if they are arrested, they might not stay in jail. So we really want to focus on being honest with the survivor and setting those reasonable expectations for them. That does not mean we are not empathetic. So saying things like, I'm so sorry you're going through this. Sometimes even saying outright, I believe you, can be really powerful for survivors. Additionally, we don't all have the same view of justice. All survivors don't have the same view of justice, and that viewpoint can change over time. So really allowing survivors to define what they see as justice, and that might mean time and space. So not all survivors are comfortable engaging with law enforcement and affirming whatever choice that they make. And then in summary, we just want to recognize and remember that not all survivors respond to sexual assault the same way. Not all survivors will want to report their assault to law enforcement. As advocates, regardless of the setting, we want to focus on survivor needs, supporting the survivors through the investigation process, if that's what they choose, regardless of the setting, whether it's safe, working with law enforcement. It's not our job to speak for people, for the survivor. Additionally, this can be really helpful. Know what you can provide and know what other resources are available to survivors. Be ready to provide those resources in a way that meets survivors where they are. So don't provide a referral that doesn't exist. And when you do provide referrals, think about the timing. Is now the appropriate time to provide this referral? Are they too overwhelmed to hear what you're saying? And then really important, know your reporting and confidentiality requirements. If you are a mandated reporter, you need to be disclosing that to a survivor at the beginning of an interaction. If there are limits to your confidentiality, whether you're a community-based advocate or a systems-based advocate, be able to articulate that in ways that survivors understand and know, so they can make informed decisions about what information they're choosing to share with you. If you have any questions about anything I just said, or any questions at all, my email is on the screen. You are welcome to reach out to me, but that is all you will hear from me. So I'm going to stop sharing my screen and kick it over to Tiffany.
Grace, real quick, there's just a few questions in the chat for you. One of them says, if I have an adult friend who I believe has been sexually assaulted, can I report it? Can I report it and the matter would be looked into?
Law enforcement does take third-party reporting. I would really think about safety in that case. So are you risking a survivor's safety in making a report for them? Thinking about their preferences. So is that something that they want to engage in? And if it's not, asking yourself, why are you making that report? Like I mentioned, any report of sexual violence, law enforcement will investigate. And that might not be, or it might be what a survivor wants in that setting. I would be happy to connect with you after the fact. I'll pop my email in the chat if you have specific, or if you'd like to talk more in depth about that.
Thank you. And I have one more question here. It says, is it appropriate to neutrally lay out the pros and cons of speaking or not speaking with law enforcement if they ask about it?
I would say the pros and cons list can look very different person to person. So for example, the pros for me of speaking to law enforcement might look very different than the pros for Natalie speaking to law enforcement, as with the cons. So you creating that list is typically what you think the pros are, not what the survivor thinks the pros or cons are. Now, what I might do instead is ask the survivor, what are the pros and cons for you of reporting to law enforcement, and talk through that with them, rather than my idea of what the pros and cons are, because that's going to look different person to person. Now, I do think exploring that with the survivor and having them come up with that list for themselves can be a really powerful way to analytically talk through potentially reporting or not. Coming up with that list as a provider for me feels like I am projecting my own bias or my own ideas around what the pros and cons are. But I don't think having a survivor do that is inappropriate. I'm going to kick it over to Tiffany now. Thank you all so much.
Thanks, Grace. Good morning, everyone. Please give me a moment to set up my slides, and then I will begin shortly. Okay. I believe that everything is set up properly. All right, so I am Tiffany Watson. I am the managing attorney at the Sexual Assault Legal Institute with MCASA. The Sexual Assault Legal Institute helps survivors of sexual assault in various legal cases, legal matters that they may be faced with as having been a victim of sexual assault. For example, crime victims' rights, employment law cases, protective orders, things like that. So we handle a whole wide variety of legal matters. Prior to taking on this role, I was a prosecutor for almost 6 years in Pennsylvania. I started out in a very small jurisdiction in Chambersburg, Pennsylvania. I got a lot of experience there, and then took those skills to Philadelphia, where I worked as a prosecutor in the Family Violence and Sexual Assault Division, focusing on those crimes. And then those skills brought me here. So I am excited to present this information. I enjoyed my role as a prosecutor. I think it's a very important one. And so let's get started. Okay. So, what is a prosecutor? A prosecutor is an attorney for the government, and that can be state or federal. And it's really important to understand that when working with survivors or victims, as they will be labeled in a criminal case. Victims, victim witness, some variation, but victim is typically how they would be referred to. Oftentimes, victims will believe that a prosecutor is their attorney. So it's important as advocates to explain that they can certainly have a crime victims' rights attorney that can represent their interest according to the law. But the prosecutor is specifically the state or the government's attorney and represents the citizens of a jurisdiction who are victims of crime. Now, in Maryland, the prosecutors are called state's attorneys. And in each jurisdiction, there is an elected state's attorney. That state's attorney then goes on and hires assistant state's attorneys who will assist them in prosecuting crimes in court day to day, because the elected cannot handle all of the criminal cases that their office is faced with handling. So that's why they hire their assistants. And those assistants are referred to as ASAs, an abbreviation. Now, those ASAs decide lots of things when it comes to criminal cases. They decide who gets charged, and that is in addition to law enforcement. So a lot of times they will speak with law enforcement about charging. Sometimes those decisions, depending on the jurisdiction, is made by law enforcement, and the assistant state's attorney will review that decision. Sometimes the assistant state's attorney will make that decision and then tell law enforcement, I think this is who needs to be charged. We'll get more into that later. They decide what crimes get charged, whether to make a plea offer or take the case to trial, what evidence to put on at trial, and what sentence to argue for after there is a conviction. Now, all of those decisions basically are up to the prosecutor. The prosecutor has wide latitude, and what we will often use to refer to that is prosecutorial discretion. The prosecutors exercise this discretion day in and day out. They are given a lot of authority. It is a very important position to hold, so prosecutors must be mindful of how they use their discretion, taking a lot of things into account when making those decisions. And I included this quote here from the Broad and Kircher case because I thought it just very succinctly added some insight to this role. And it says here, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in the prosecutor's discretion. So there are various stages, as I mentioned before, where the prosecutor will exercise that discretion. One of the first stages is at the charging stage. Again, prosecutors will decide who to charge and what crime to charge. And when they're making this decision, they are starting with the statute or the actual crime itself that is in the criminal code, because there are elements in each statute that the prosecutor must be aware of, because those elements are what they have to prove at trial. Not only at trial, but if there is a plea agreement, the prosecutor has to show a judge that, hey, we have the evidence that would be able to prove these elements if we were to go to trial. And we'll talk more about plea offers and plea agreements later. So, and when I say elements, what I mean are the various parts of a statute or the crime that a prosecutor is required to establish at trial. So for instance, the crime of harassment states that it is a crime for another individual in or around a public place, or maliciously engaging in repeated behavior that seriously annoys or alarms another individual with intent to annoy, alarm, or harass after being reasonably requested or warned to stop the behavior by the individual or someone acting on behalf of the individual without any legal purpose. So there are a lot of elements there that a prosecutor has to establish in court if the case were to proceed to trial. So prosecutors have the obligation to, at the charging level, to believe that they have the evidence to meet those elements before charging and that they're charging the correct person using that evidence in order to meet that obligation that they will ultimately have to meet at trial and prove those elements. You may have heard this standard beyond a reasonable doubt, which is a very high standard. So even at this charging level, prosecutors have to be ready to say, I know that this is the person that committed this crime. Well, you know, I have the evidence to prove that this is the person who committed this crime, and this is the actual crime that they committed. And I have that evidence and I can show that at trial. So that is the ethical obligation of the prosecutor at this level and throughout the case. Now, crimes can range in severity. Felonies and misdemeanors hold very different sentences. Felonies are carry much more serious sentences and are considered the more serious crimes. Misdemeanors are also serious, but carry a much less serious sentence, and the effects that go along with misdemeanors are not as serious as felonies. An individual can be charged with multiple charges for one act. For instance, an assault. An assault can be various degrees. An assault can be called a simple assault, but there can also be evidence that can aggravate that assault and take it to a higher degree. But that can all be based on just one act. And again, that is up to the prosecutor, depending on the evidence. Now, after the charging stage, once the case is moving along towards trial, the prosecutor will then want to meet with the victim. And I would always like to meet with the victim very early on to introduce myself, to answer any questions, and to just begin to build that rapport. However, because prosecutors and prosecutors' offices are often inundated with lots of criminal cases, sometimes even myself, I didn't always have the chance to meet with my victim right away. So victim witness coordinators who worked in the offices that I worked in would assist me in that. And it's a very, very important role. And it's a role that people who hold those roles, I would look to them to help me, because that's a very important part of the criminal case, is making sure the victim understands and that they feel that they are part of the case, right? Because the victim is the one that is going to present the facts and the testimony, right, that the prosecutor needs in order to show that the crime was committed and this is the person that committed it and they should be convicted. So it's important to have the victim along at every stage of the case. So prosecutors must make a point to speak with the victim or have their victim witness coordinator speak to victims about the case status. If there is going to be a potential plea offer, if the prosecutor is thinking, we're not going to take this case to trial, it's important to inform the victim of that and actually talk to the victim and get their thoughts and feelings. That's actually something that's required by statute, to take a victim's feelings into consideration when making that decision. A prosecutor will speak with a victim in order to prepare their testimony should they decide that the case will move towards trial. preparing the testimony of a victim is very important because, you know, the victims don't typically know what's going to happen at court. So prosecutors need to explain objections, need to explain if it's going to just be in front of a judge or a jury, explain, you know, here are the things that you can say on the witness stand. Here are the things that you can't say. So it's very important to prepare a victim's testimony. It's also important to explain to victims, and advocates can help with this because prosecutors don't always explain this. It's important to explain that those conversations between the prosecutor and the victim are not confidential because, again, remember that the prosecutor is not the victim's attorney. So there is no attorney-client privilege that, say, a defendant may have with their attorney because they've hired or this attorney has been appointed to represent them personally. So because those conversations are not confidential, if a prosecutor learns new information, especially new information that may be something that could be damaging to the case, or information that the defense that could be helpful to the defense. I know that that can sound that sounds very weird, but prosecutors have an obligation to provide all discovery, all knowledge, because someone is being charged with a crime. So under the law, a prosecutor has to turn over all of that information. So it is really important for a crime victims' rights attorney to work along with the victim and to talk to a victim about what they might want to share and what they might not want to share with the prosecutor, because it's, at the end of the day, it's all going to come to light if it's shared with the prosecutor. So moving on, we have decided who's going to be charged, what's going to be charged, and we've met with the victim. So now there are potential outcomes for the case before it even reaches the trial stage. So a plea offer, like I mentioned before, can be made. And the defendant may plead guilty to a lesser offense or plead guilty to many charges to avoid going to trial. Now, the pros of this are that it's a sure thing. The defendant knows, I will be convicted of this charge and I'm going to receive this sentence as long as the judge agrees with the sentence and agrees with the plea. That's a caveat. Another pro is that it saves the victim from having to testify. Testifying can be and is often very re-traumatizing, especially for survivors of sexual assault. You're sitting before a judge or before a jury of strangers in a big courtroom, telling them one of the most horrific, telling them about one of the most horrific days and very intimate details. So it saves a victim from having to go through that and saves them from having to be cross-examined by a defense attorney, which is always re-traumatizing. Cons of a plea agreement are that, you know, in the same regard, the victim doesn't get their day in court. Some victims feel that they can regain their autonomy. It makes them feel like they are truly heard. They want to tell their experience. They want people to hear and listen. So you don't get a chance to do that. Another is that a victim may not agree with the ultimate offer that the prosecutor makes, though the prosecutor has to take the victim's desires and thoughts into consideration. At the end of the day, the prosecutor will make their final decision. And plea agreements are often affected by the circumstances of the state's attorney's office and what's going on with the defendant. If there are too many cases to take to trial, then a plea offer may be the only thing that can happen with the case. or reaching that plea agreement may be the only thing that happens. And sometimes a judge will try to push a plea agreement because there are just too many cases to take to trial. Another outcome is that the prosecutor could use their discretion and think that, we're going to drop the charges because for a variety of reasons, there's not enough evidence. Exonerating evidence has come to light, or evidence that tends to prove or establish the innocence of the defendant, or that witnesses are no longer cooperating or available. And I would just note that a new law that will be effective on October 1st requires that when charges are dropped, or if the state's attorney decides not to file charges at all, and the victim makes a request, the prosecutor needs to sit down with the victim or meet with the victim to explain why that decision was made. And that is a very important law, especially when it comes to cases of sexual assault, because a lot of times a prosecutor will decide based on their discretion that there just isn't enough evidence to move forward. And it is important to explain to survivors why that decision was made, to provide any sort of closure that a prosecutor can provide. So once the prosecutor has decided we're going to move this case to trial, they will need to thoroughly review their evidence. And evidence can come in the form of photos, police testimony, physical evidence, text messages. And the evidence will be controlled at trial by the rules of evidence. And the judge will actually decide what is admissible and what is not admissible. So the prosecutor can be prepared, for admitting certain pieces of evidence, but it is ultimately the judge's decision. But a prosecutor must be aware, obviously, of the rules of evidence, because that is what they will use in order to prepare for trial, and anticipate what those evidentiary rulings will be. And not everything that a prosecutor has will be admitted. For example, hearsay statements or rumors, depending on, rumors will likely never be admitted, but hearsay statements, depending on the rules of evidence, can be admitted or may not be admitted, depending on what the actual rules of evidence are and what the actual piece of evidence is. So prosecutors will consider all of that as they prepare for trial. Now, on the day of trial, what will happen? Typically, if it's going to be a jury trial, there will be jury selection, and in court that is referred to as voir dire. Or the judge, it may just be a bench trial or a judge-only trial. But regardless of whether it's judge-only or a jury trial, there would be opening statements by the prosecution first, and then by the defense, should they decide to do an opening statement. The prosecution will then present their case in chief through testimony, presenting the evidence, and the defense attorney will be able to cross-examine that actual live testimony and ask questions about that evidence. Once the prosecutor is done presenting their case in chief, they will close out their case. And the defense has an opportunity to ask the judge to not send the case to a verdict. Basically, if it's a jury trial, to ask the judge to not send it to the jury, but decide that the prosecutor's evidence was so insufficient that it should not go to a jury. So the judge will make his or her ruling on that motion. If the judge decides that the evidence is sufficient and it can go to a jury or can go to verdict, then the judge will decide, will make that decision and ask the defense, do you have a case to put on? Now, the defendant has a Fifth Amendment right to remain silent. That means silent in every respect. The defendant does not have to put on a case at all. So in addition to not having to testify, the defendant doesn't have to present witnesses, doesn't have to present any sort of evidence. The defendant has the right to remain silent in every respect. Should the defense decide to put on a case, they will present their case in chief. The court will move to rebuttal if there is any, and then closing statements by the prosecution and by the defense, and then the case will move to verdict. Now, if the verdict is not guilty, the case is done. The prosecution cannot appeal. The defendant will not be able to be tried again on those same charges for those same acts. The case will be done, and the defendant cannot be held. If the defendant is, incarcerated, will be released immediately, and the case is done. If the verdict is guilty, then sentencing will be imposed either that day or there will be another date set for sentencing. And the prosecutor's role in this is looking at the guidelines, the sentencing guidelines, to craft a sentence that then the prosecutor will make arguments for at sentencing. However, the court is the ultimate decision maker for the sentence, and the court is also bound by those sentencing guidelines, but ultimately the court imposes the decision. Before sentencing occurs, victims are able to give a victim impact statement, and advocates are very important in helping victims craft this impact statement, helping victims understand what needs to be in the statement and what should not be in the statement, and how to focus the statement so that it can be as impactful as possible for the judge, because the judge is required to consider the victim impact statement before imposing sentences. And the impact statement can be extremely powerful. I've heard judges say, I was going to impose this certain sentence, but after hearing that impact statement, I am so compelled, I'm changing my mind here today on, at the bench, because that was just so impactful. And I did not know all of that before I decided, or before I had an idea of what sentence I was going to impose. So this is a very important tool, and I cannot stress that enough. That is all I have to offer at this time, and I will move into addressing any questions. Here's the contact information that you have seen in other slides, and I will stop sharing my screen. Are there any questions? All right, thank you.
Thanks, Tiffany. So now we can go ahead and move on into our final portion of today's presentation, which will be our sexual assault response team panel. So I'm just going to ask all our panelists to turn their cameras on. Our training and engagement specialist will spotlight you all so everyone can see you. Right. Let me just set up my questions and we'll go ahead and get started. Okay, so hello. We're now going to move on to our sexual assault response team panel. Before we begin, I just want to do a brief introduction of each of our panelists. And thank you all so much again for volunteering your time and being here today. So to start out, we have Tanis Klein, who will be representing the role of an advocate. Tanis joined the Family Crisis Resource Center in August of 1999. She was originally hired as a counselor. Some of her earlier responsibilities after the formation of her county sexual assault response team included participating in SART meetings, providing advocacy to sexual assault victims presenting at the hospital. And 24 years later, she's taken the role of victim advocate with her throughout her various positions at the Family Crisis Resource Center, and she is currently serving as deputy director. So thank you so much for joining us today. Additionally, joining us to represent the role of the forensic nurse examiner, we have Jennifer McNew. Jennifer is a 2004 graduate of Shepherd University with an associate's degree in nursing and a 2013 graduate of Pennsylvania State University with a bachelor's degree in nursing. She has 18 years of experience as a forensic nurse and has provided care for over 1,300 victims of sexual violence in her career. Jennifer is the current forensic nurse manager at Meritus Medical Center in Hagerstown, Maryland, and manages a team of forensic nurses that provide forensic care for approximately 700 plus victims of violence every year. Um, she is qualified as an expert in the court of Pennsylvania, Maryland, and West Virginia. So, hi, Jennifer. Thank you for joining us. Moving on, we have Mary. She has been practicing. She will be representing the role of the prosecutor. So she has been practicing since, or prosecuting since 2011. She was an assistant state's attorney in Cecil and Carroll counties before coming to Garrett County. Mary began focusing on special victims unit related cases in 2013 as the chief child abuse and sexual assault prosecutor, handling a variety of cases, including physical child abuse, childhood abuse, sexual child abuse, child neglect, adult sex crimes, child pornography, domestic violence, murder, and human trafficking crimes. So thank you so much, Mary, for joining us. And then finally, we have Jason Baum to represent law enforcement. Sergeant Jason Baum began his policing career with the Pittsburgh Police Department in 1994, where he was the team leader of their SWAT team. In 2004, Sergeant Baum became a Montgomery County police officer and was assigned to the Wheaton Glenmount District. In 2015, he was promoted to the rank of sergeant and became the supervisor of the Special Victims Investigation Division Sex Assault Unit. So, hi, Jason. Thank you so much for joining us today as well. Just as a reminder, my name is Natalie. I'm MCASA Safe Start Policy Advocate. I'm sure I've said that now a million times, but just to reintroduce myself before we get into the panel. Just to give a rundown of how questions will go, I'm going to ask a general question for each of our panelists. So for organization purposes, I'll start off with Jen, and then it will go to Jason and then Mary. And then Tanes, some of your questions are more specific to advocate work. So when we get to you, I'll give you your question. So it's phrased in a way that's more applicable to your work. If you miss a question or your audio cuts or you need clarification on anything, please let me know and I'm happy to repeat or clarify everything. And then just for the audience, if you have questions that come up throughout the presentation, you can put them in the chat and I'll try to incorporate them as time allows. And if not, I can always reach out to our panelists and get responses for you and email them later on. So our first question is, what is important for a victim advocate to know about your role in the sexual assault response process? So Jen, I will start off with you.
So I think one of the most important things to know is that we always remain a nurse first. So we kind of wear two hats in this job where we're healthcare provider, but then we're also working with the legal system. And healthcare always comes first. So, we may not get to the forensic piece for quite a while, depending on the dynamics of the patient's healthcare needs. And we also have to be objective and unbiased. We are a neutral healthcare provider. So, obviously we're there to take care of our patients, the victim, and we're going to do whatever is best for them at the time, but we cannot show bias, especially when it comes to court, that we're all for the victim. So I look at it as, because I've had this asked on the stand before too, is about if I believe my patient. Well, I believe all my patients. If they come in complaining of chest pain or a headache, I'm not going to question them if they really have chest pain or a headache. I believe whatever they tell me. And it's really no different in an assault versus any other healthcare issue. So we do advocate for our patients, but we're just not advocates. So I like to kind of differentiate those two out.
Thank you so much. Jason, I'll hand it over to you.
Right. So obviously our role in all of this is to gather all the evidence and look at it objectively, look at everything that we're able to gather, and determine if throughout the course of the investigation, if we have enough probable cause to make an arrest on the case. The important thing for us as we're going through the investigation is to have it be a victim-centered approach or victim-driven. So whatever the wishes are of the victim, no matter where we are throughout the investigation, we honor those. And that's one of the things that we make sure that we tell them, especially when we get victims that are a little reluctant to speak to us or to provide us with all the information, is that throughout the process, it doesn't matter where we are in the process. If they want to stop the investigation, if they're not comfortable with it, if they need some time to think about how they want to move forward, no matter where we are, we stop, we set that case aside, everything stays in the case file, we provide them with contact information, and then when they're ready to continue or move forward, then we pick up right where we left off. And then we continue, throughout the investigation. Once we have the investigation completed, we provide what we have to the prosecutor's office, and then they take over, obviously, with the trial and charging.
Thank you so much. And Mary, I'll hand it over to you.
Okay. I would echo exactly what Jason said, that this is victim driven, and the state's never going to force anybody to go forward if they're not ready to or choose not to. We also have a multidisciplinary team. I think most counties in Maryland do, that meets, and that's comprised of law enforcement, social workers, a physician, mental health care. And so we come together as a team as well. And sometimes prosecution isn't always best for a victim if they are reluctant or for whatever reason, maybe it's just not best to move forward. So we let that be victim driven as well. But what we do want to provide are the other services, the mental health services, the support from social workers, counseling, all that, whatever a victim may need is what we want to provide. And I think that's what what we're trying to do here as well is the advocate is incredibly important in prosecutions to help with conveying victims' needs if they're reluctant to talk with prosecution. So I think that advocacy role is very, very vital in all prosecutions with regard to a sexual assault.
Thank you so much. So Taness, my question for you is, how would you explain your role as an advocate to other service providers, such as law enforcement, a forensic nurse, or a prosecutor?
Well, my role as an advocate is to support the victim in whatever way they happen to need at the time. I'm not there to ask questions or have them review the entire narrative that they do for the purpose of the evidence collection or an investigation. I'm there to listen, to answer questions if I can, to discuss next steps, to provide resources, talk with them about what their needs are. There are times when I spend a small amount of the overall time with the victim. They may need or prefer that I am helping a family member or a loved one that is there so that they can focus on getting through the exam and that whole part of the process. There are times when I am trying to diffuse a situation. If there are family members there that I'm hearing a lot of the myths regarding sexual assault. Just a recent example when there was a family member, and I'm sure that they meant well, but said, hey, you have a mean right hook, you should have hit him, I would have hit him. So kind of taking that and while still showing respect to the other loved ones that might be there, but making sure that the victim is cared for and is recognizing that what they did that allowed them to be out of that situation safe and they're at the hospital being checked out is the most important thing. So my focus is only the victim and what their needs are so that the other parts of the whole response team can fulfill their roles.
Thank you so much. So before we move on to our next question, we got a question in the chat for Jen. Somebody asked, can the survivor see the results/notes of their safe?
So yes, most of the time. So results we don't ever get right away. So if we're talking about evidence collection, 6 or more months until the kit is analyzed and results are back, and that comes from law enforcement, not us. At the end of the exam or during the exam, we will talk with them and tell them exactly what we're seeing. Like, I see injuries, or your exam is normal, but that does not mean that nothing happened. It's normal to have a normal exam. As far as getting the records for adults, usually it's not an issue. If we're talking about a minor, we always check with our investigators first before we release anything, just because of the dynamics of investigations and everything. And we don't want parents getting a hold of, especially like what the child might have told us that the parent doesn't know and things like that.
Thank you so much. So moving on to our next question. How do you work with victim advocates throughout the sexual assault response process? So for example, before, during, after an exam, during interviews, etc. So Jen, I'll give it back to you to answer this.
Sorry, my medical record popped up and okay. So one of the most important things I think is making sure that we're on the same page and working together. They understand our role, we understand theirs, which usually, if we work together a lot, we know that. We try to meet together at the same time so that the patient can tell what happened to them once and we both hear it. If that's possible, sometimes forensic nurses have to be called in from home, which could be up to an hour away, as well as advocates in the middle of the night. And it just depends. We're not going to make the patient wait an hour if, we're there, but the advocate isn't. I think another thing too is fill the silence. I think that's a big, I won't say issue, but something that we happen to see sometimes in our role is that, we have a lot of task-oriented things that we're doing during our exam, getting our evidence ready, getting our camera ready, documenting things like that. And so we can't be talking the entire time. So that's the perfect opportunity for the advocate to start talking and it can be about whatever the patient wants to talk about. If they want to talk, they might not want to, whether it's the services that they can offer, start talking about their safety plan, or they want to talk about their pets or movies or things like that. Sometimes they just want to talk about other things to keep their mind off what's going on. As far as before and after, I guess kind of as well, we more so after, we have a multidisciplinary team that we meet every other month. Most people know them as SARTs. We call ours FRT because we see all victims of violence. So it's forensic response team. So we all come together every other month and kind of talk about a lot of different things, our agency updates, and then any problems, issues, and we do case review. So then everyone can kind of give their input on where we are, with that case or that victim, as well as safety plan is a big thing. So whether the advocate is completely handling the safety plan, whether we are assisting somehow in that situation, especially if the patient's being admitted, or if we have to do an unsafe discharge because the patient has nowhere else to go. Shelters are full everywhere. So sometimes we have to do that as well.
Thank you so much. Jason, I will hand it over to you.
Okay. So I'm sure probably every jurisdiction is a little bit different on the amount of interaction that law enforcement and the advocates have. In Montgomery County, I probably have more interaction with the advocates just because I'm the co-chair of our SART. So just being in our team meetings, I have a little bit more interaction with them. The investigators themselves don't have a lot of interaction, and we do that somewhat purposefully. Not that we, are not communicating with them. The communication happens throughout, but so if we're interviewing a victim, we do what we can to not have the advocate in the interview with us unless the victim really feels that they need that. And the reason for that is we try not to make the advocates witnesses in our cases. We don't want them, and I'm sure they don't want to be subpoenaed for our trials and have to sit in court all day. So they may come to the interview, but we'll have them sit outside and just be there if the victim needs them. Probably the most interaction we have with them is throughout the investigation we have. So investigations take a very long time. And for them to, some of them to actually charge the suspect takes a long time. And we'll get, the investigators will get calls from the victims throughout the process, getting frustrated with the process, or we'll start to see that they're having a really hard time processing this, and they'll voice that to us. Sometimes they'll call us angry with us, but if we feel that there's a bit of a decline with the victim, or they're having a difficult time processing, or if they call and make certain comments to us that are concerning, then we reach out to the victim advocates, we let them know, and then they have an advocate get back in touch with or contact the victim so they can make sure that they have those resources and that they're plugged into that resource. So that's probably our biggest and most frequent interaction with the advocates.
Thank you so much. Mary, I'll hand it over to you.
Thank you. Unlike for law enforcement, we prefer to have an advocate in the room with a victim for a bunch of different reasons. The first being ours is work product. When we meet with a victim, it's covered under our work product, so it's not necessarily discoverable, meaning we don't have to let the defense attorney and defendant know that we had this meeting. This is just preparation for trial. So I think that gives us a little bit more leeway in that the advocate in the room with the victim generally makes it easier for the victim. It also, because they've already now established trust with the advocate, knowing that that advocate works with us on a pretty regular basis, I think can put that victim at ease, which I think is incredibly important. Helps that person, that victim, be able to be open and honest with us because they've already done so with the advocate who's in the room. So we find that to be particularly helpful. I also generally have somebody else in the room, maybe law enforcement back in the corner, just in case the victim says something a little different to me than perhaps they had said to law enforcement, because just like he was talking about, I don't want to make the advocate the witness. So that's why I have law enforcement generally in the room, or a CPS investigator if it's a child. And that's just so that I do have another witness available. I don't want to become a witness in the case, and I don't want the advocate to become a witness in the case, because that advocate could sit with at the trial with the victim if requested. And I think that's a vital role that I don't want to disrupt by making somebody a witness. And that's the way we deal with that. So we actually prefer when the advocate is there, because it helps us in our communication and establishing rapport and trust. Just the advocate being present helps with that.
Thank you so much. So for Taness, your question is, can you tell us a little bit about your work with victims and other professionals before, during, and after a sexual assault forensic exam?
Absolutely, thank you. So as far as the before, when I am called out to the hospital, if law enforcement have brought the patient to the hospital, or they've already been contacted because the victim has decided to report, law enforcement may already be there, already be taking a statement from the victim. The way things tend to work in our area is there's going to be a responding officer based on the jurisdiction, as to where the offense happened, and then it will be turned over to an investigator. So they're going to be in communication with various members of law enforcement. So the before may be just seeing law enforcement coming and going. I may be in the room present, as Sergeant Baum said, that sometimes they do request to have an advocate there, kind of weighing that balance between, what is most beneficial for the victim, obviously, but also not hindering my role as an advocate, not hindering anything having to do with the investigation. As far as the before with the victims, our forensic nurses are amazing. Generally, when I'm there, forensic nurses have already had that initial contact with the victims. So they've already talked about their options. They've already talked about the process of the exam. So before the exam takes place, when I'm meeting with the victim, I'm just checking in to see if they have any questions, if they have any concerns, if there's any immediate need that needs to be addressed, or any way I can be helpful there. For example, if they are concerned about safety when they leave there, that is something I can be working on with their permission. If they need a safe place to go, I can be dealing with that while then, the rest of the exam is happening. The during part is going to depend on what the victim wants. If they want me in the room during the exam, I am absolutely there. Obviously, I am up at their head, providing as much dignity, as much privacy as we possibly can. And as Jen mentioned, sometimes the victims, as they're going through this process, they want that distraction of talking about anything and everything that is not related to what they're going through. So obviously not impacting what the forensic nurse needs to ask and to be talking to them about during the exam. I can be up there talking about anything else or nothing else, just depending on what they need. And then the after, there may be the follow-up with law enforcement. And again, if it works for law enforcement that I'm present in the room for a follow-up interview, I may accompany them there, or I may accompany them and again, wait outside based on what the need is of the victim and what the need is of the other partners in this whole process. And the after with the victims, after that exam is actually done, back in the room with them, as was mentioned with the forensic nurse, they have a lot to take care of before and after that exam that the victim is not present for. So I'm there with them, I'm there with family, if family happens to be present, and we can do, troubleshooting of maybe some of the more concrete issues. Do they need clothing to change into before they head home? Do they need some kind of statement to say that they were in the emergency department for maybe a professor at college or an employer, obviously not stating that they were there for a sexual assault exam, but that they were seen in the ER. So those very concrete things I'm going to work on, obviously providing them with resources. Now, as far as actual information, written information, cards, brochures, anything I might have for them, I tend to wait till the very end of the entire process before they're ready to go home to provide that to the victim, because otherwise they're going to be sitting there kind of awkwardly holding the information I give them. But our forensic nurse will bring in their discharge papers and also a large envelope for them to keep everything in. So that's when I provide that to them so they can keep all of that information together. And then because I've spent that time, kind of building that relationship with them, if there is any follow-up, any information, any content that is appropriate for me to be a part of. Obviously, I'm not going to be a counselor. I'm not going to be the person that's necessarily providing any assistance with the protective order process, if that is part of it. But I definitely try to, kind of maintain that contact at whatever level they're comfortable with, so they're not kind of just dropped at the point that they leave the hospital.
Thank you so much. Before we move on to our next question, I did get a question in the chat for you. Any idea of the percent of male victim advocates and how receptive victims are to having a male versus female? Are agencies required to have male victim advocates? And if so, are they restricted to female advocates or not? I ask because I have a male friend interested in this role, but I think there is some resistance because he is male.
I don't know that I can speak to the number. Jen might know that a little bit better than I do. I know in our hospital, we have 4 forensic nurses, all of whom are female. So I'm not sure really of what that number is outside of my little small circle here in Allegheny County.
Thank you.
If I could say something with regard to that, we don't only have female assault victims. I mean, there are male assault victims as well. I appreciate, anybody who wants to be involved or be interested in becoming an advocate, because the more we have, the better, in my opinion. But I think that's something that someone could specifically look into. I don't think it's necessarily limited based upon gender, but we do have male assault victims as well. So, and I think that's something that society tends to forget.
Thank you so much.
I'll add on to that also, just from being the only guy in here. So we are law enforcement. I mean, while we have specific role, we are sort of advocates with the victims as well. And, half of my team are males, and, probably 85 to 90% of our victims are females. And I think it's more about the compassion and the personality of the advocate, of the person working with the victim, than it is their gender. If you can show that care and compassion and have that person feel comfortable with you, then I think that's the thing that matters most. We walk into the process, with female victims, 30 minutes after the most traumatic thing that's ever happened in their lives, and it was committed by a male. And being able to just show some concern, some compassion, they open right up to us. So I think, I think it would be the same with a victim advocate as well. The more it comes down to the person than their gender.
Thank you so much. Jen, did you want to add anything?
I mean, not really. I think Jason pretty much hit it on the nail. I honestly have never worked with a male advocate. I teach at a university, and we do like mock exams with standardized patients, and they do have a transgender male advocate, and we've never had an issue, and he's absolutely wonderful. I know they specifically asked about advocates, but there are male forensic nurses as well. I did have one. He doesn't work here anymore, and now I have a transgender male on my team right now, and I've worked with other males too. I think from a healthcare perspective, it's I mean, a lot of doctors are men, so a lot of gynecologists are men. So from that perspective, it's not, I think, as big of a deal as long as they are trauma informed and compassionate.
Thank you so much. I think that's a great way to put it. All of you did a great job. So thank you. And then my supervisor, Laura Jessic, is on the call. She's MCASA's sexual assault response team and sexual assault kit initiative project manager. And she messaged me that she wanted to add something in. So Laura, if you want to pop in, you can add.
Yeah, I just thought I'd mention that, and everyone kind of hit on this anyways, but under the sexual assault kit initiative, where we're looking at testing historical kits that in some cases are like 30 years old, there was some initial research done, and one notification advocate that did a lot of notifications with these survivors years down the road asked this exact question, like, what do victims prefer? Do they tend to respond better to a female individual doing notification, or is a male individual an issue when the victim is female, and vice versa? And the initial research noted that survivors really don't care. They don't, gender isn't a issue to them, it's how they're treated. So if you have a female advocate, nurse, detective, prosecutor who really just is not trauma informed with them, they tend to shut down, versus somebody who is open and trauma informed and willing to talk to them and listen to them. That is what matters to the survivor. So everyone really touched on that, I think, anyway. So I don't know why I felt the need to chime in, but that was some initial research, and I'm hoping it might be published in the future. And then MCASA is doing surveys with survivors that are doing notifications. So we're trying to get to some of this information as well, specifically for Maryland. So should be interesting. But that's all. Thanks.
Thank you, Laura. And that was very relevant. So thank you for sharing, and reiterates the points that our panelists made. So I'm going to move on to our next question. This is for everyone. This doesn't have an advocate specific question also. So from your perspective, what do you think is important for survivors to know about anonymous exams? So I'm going to hand it over to Jen.
Okay, so I think one of the most important things is they've got time to think about it. I was doing this long before we ever had anonymous reporting, and we had 5 days, and it was now or never. And that was awful for someone to have to make up their mind in that moment, or go home, think about it, and maybe come back the next day. But then we could have lost a lot of evidence in the meantime. So giving them that opportunity to have time to think about it, especially since we know 80 or more % of the time it's someone they know, and there's a lot of other issues going on with that. It's not like it was just a stranger and I want them to go to jail. Regardless, everything is confidential. So even though we know who the patient is, and we're creating a chart and we're writing things down, everything on the inside of the kit has the patient's information. Everything on the outside of the kit does not. So when we turn it over to law enforcement, all they know is that a sexual assault happened in their jurisdiction. This is the number to link them to us and to the kit. And when and if they decide to report, the kit would then be opened, and then they would have all of the information, and it would link back to that patient that we saw and our documentation as well as the evidence. We also, our consent form, we kind of go over like a list of pros and cons with them, which I must have gotten around. So it's important for them to know, like, yes, this gives you plenty of time to think about it. Unfortunately, there are some cons, and I don't want to steal Jason's thunder here. I'm not sure what all he's going to say, but things like, evidence could be lost at the crime scene or the suspect, and interviews couldn't happen, and they couldn't investigate right away if they don't know things. So we just kind of go over all of those pros and cons with them so that they're making an informed decision. And then just, we give them information on, if they do decide to report down the road, how to do that.
Thank you. So Jason, I'll hand it over to you.
So, selfishly from, our side of it, we would much rather they report, because, like was said, there's a lot of things outside of the forensic exam that we do and that we try to collect for each case. And the longer the time frame is where we're notified and are able to investigate, the more things that we're going to lose that we could potentially bring forth as evidence. One of the things that we do in Montgomery County, and we started doing this probably about 2.5 years ago now, So one of the options that victims have when they go to the hospital is, so they're given a third option. They can do a standard report, anonymous, or they can choose an anonymous consultation with us. So what would happen is we're on call 24/7. So if they choose to have an anonymous consultation with law enforcement, the forensic nurses would then call the detective who's on call and put us on the phone with the victim. We ask them absolutely no questions at all. The sole purpose of the phone call is for them to ask us questions about the law enforcement process. What are we going to do? Any concerns that they may have about, our response, or who we're going to talk to. And there's a study going on, about this process to see how that affects a victim's decision to either standard report or remain anonymous, just by answering those questions or concerns that victims have. And we found that that process actually has been very helpful, in them making, a better, or a decision, whatever decision is best for them. So.
Thank you, Mary. I'll hand it over to you.
When it gets to the prosecution, again, I tend to agree that the sooner the better, for selfish reasons, for prosecution as well. I'm not going to repeat everything that Jason said, but we also have an additional wrinkle that defense attorneys try to use as a tactic, that the delayed report, and we generally can overcome that, but maybe somebody on a jury panel at some point is skeptical. Why would this person wait so long? So we start a little behind the 8 ball, instead of being able to just move forward like we would on a regular report, and being able to move forward pretty quickly. But I think what would be important for patients or victims to know, at the level when it gets to me to prosecute, that exam is going to be shared with defense. So it's not confidential at all at that point, because it's part of our discovery process. I have to turn it over. I think it would be important for them to know that up front. I also think, and I can tell you, in my office here in Garrett County, we try to be very transparent. So anybody that's going to be faced with this knows that they're going to get transparency out of our office. We're never going to make a plea offer without their input and involvement. And I think that's really important too, because I think the general consensus is that, oh, these prosecutors just sweep everything under the rug and it's a slap on the wrist. That's not the case with our office. I would hope it's not the case with anyone's, but I'm not that naive. But here, absolutely, the victim has input before any plea is ever offered. And there are a lot of reasons for a plea. It limits their ability to appeal something later. And it also, if the victim is uncomfortable and doesn't want to testify, we can get the same kind of results without putting them through that process. I think it's important that they know the prosecution is on their side, but we will, of course, bring up issues that may be deemed as problems, a delayed report, for instance, or other things, extraneous things that maybe law enforcement has uncovered that is going to be a stumbling block for us in trial. We're not going to hide that from them. We want them to be fully informed. We want them to be prepared for that, and to the extent we can prepare them, the better. I think it's also important for them to know that we can be halfway through this process and even have been to court multiple times. And if they want to stop, we're going to respect that it's not about us and our prosecution. It's still about the victim. So it doesn't mean once they start the process, they couldn't ever change their mind and pull back. We're going to respect that. We'll probably try to salvage something out of that, but we're never going to force them to take the stand. We're just never going to put a victim in that situation. And I think part of this was how often they would have to meet, like with the state or the prosecution. And I think that's different. That's on a case by case basis. But I think in general, an adult could expect to meet with the state 1 to 2 times, unless requested more often. But with regard to a child, the way I do things is I bring a child in, we talk a lot, meet often, before I ever ask them about the incident that's actually bringing them to me, because I want to establish that rapport with a child. I have the luxury here in this office to be able to do that, so I can meet 5 or 6 times with a child before we have to really talk about the bad stuff that happened to them. And I think that goes a long way in making sure they're comfortable. They come to my office, if, depending on their age, we might color for a while or play a board game or something like that, but it's early and often is the way I would like to meet with a child who's been victimized.
Thank you so much. Tanessa, I will give it over to you.
Thank you. So I pretty much echo everything that has been said, but I will say that I really like the anonymous consultation as an option. We had one victim who, after doing the anonymous report, a few days later, she just simply asked if she could speak to an investigator. And we had an investigator that was willing to do that without anything going forward, just to kind of make that decision whether or not, and that worked beautifully. So I do like that sort of as a policy, having that option. One thing that, I'll just add to this is, working with a victim, if they're really struggling, whether or not to have evidence collected versus just having medical care. They're in the ER, this can be an absolute perfect option for them, because it can really mean the difference if they're looking at the fact that if they do decide to, go forward with a criminal investigation. And I don't mean this in a bad way, but it can sort of take that process and it just moves. And that can feel sort of out of control for a victim, that you have this investigation happening and possible court looming ahead. And this anonymous report process can be the difference for, for a college student, for example. I can get through the rest of the semester and then go forward. Knowing what the cons are, obviously, with some evidence at the scene and those types of things being lost, but it can mean the difference, in that respect. Or I just need to talk to my family, for a bit, see what is best. So it does give them that option that they didn't have before. Reflecting what Jen said, I was around too when that wasn't an option. You had to make that decision. And if you didn't, there was no evidence collection. So I'm really grateful for victims that we do have this option for them.
Can I add one thing that I thought about? Very important to know is if the assault did not happen in Maryland, that could be an issue. There are other states that do not do anonymous reporting, and it becomes a huge problem. So we actually have been trying to work on all of the states to try to figure out who does anonymous and how long, so that we have that information. But we've had some cases where we've done our thing, we've collected our kit, we've done an anonymous, we've called that jurisdiction, and they're like, oh, we don't do that here. I think one was New York, maybe, or Rhode Island. I forget, one of those two. DC is a problem. So just keep that in mind, that it's not like, oh, we always can do this, just in case the assault happens somewhere else.
Thank you so much for sharing. So I think we have about 3 minutes left in terms of time. So I'm going to go ahead and end our panel now. Thank you all so much for attending. I really, really appreciate your time and your insight and your energy and all the time you put into prepping for this as well. So just a big thank you. Again, I think Alyssa is going to put the evaluation form for the training in the chat. But we have 3 minutes if anybody wants to. Somebody asked in the chat, Jen, I don't know if you would know. Somebody asked if Virginia does anonymous exams.
I'm not sure. We have Maryland, Pennsylvania, and West Virginia on our forms because we are this close to both of
Bordering.
them.
Yeah.
I can't remember if we've had a Virginia one or not.
To address this question in the chat, I did research on which states offered anonymous exams, so I can send out an email actually and explain the research that I found as well. Because Virginia should be on there. But that's all I have. If anyone has any other questions they want to add in the chat, yes, I'll send that out. Before we go in our final 2 minutes.
Natalie,
It's
it looks
always
like
awkward
there's someone in the
virtually.
chat. Sorry, it looks like there's a question in the chat says, how do we work better with the parents of the kids who suffered from sexual assault?
Okay. Do any of our panelists want to take that?
I can say from a hospital's perspective, we always bring it back to what's best for your child, especially if there's, which unfortunately, I use mom as an example because that always seems to be the case. Mom doesn't believe the child is protecting dad or the boyfriend or whoever it is. And making sure that they understand, we have to do what's best for your child. If someone is hurting your child, wouldn't you want to know that? Wouldn't you want to help your child? Just kind of put it back on them. If they get to be too much of an issue, we just kick them out of our ER, but hopefully that doesn't happen too often, but unfortunately it does.
That's a great source of frustration for us too, when parents choose to support the abuser instead of the child, and it's something that we encounter pretty frequently. Sad to say, but what we do in that situation is if they're obstructing what we're trying to do, sometimes we get CPS involved. They're already generally involved to begin with a child, but in terms of some interventions with parents, if they're not going to protect their child, things can happen to them as well. So that's how we try to deal with that if it gets to the point where we can't control things. We just need to make sure that that child is safe and is in an environment that is healthy for them. And sometimes being with a parent that's not going to believe or support them isn't that healthy environment.
Thank you so much. So it's 12 o'clock, so I will give you all back the rest of your day. Thank you so much for attending the meeting. And yes, I will send out all the resources that I shared. I'll also really quickly put my email in the chat. If anyone is interested in contacting me, if I said I would send something and I forgot that I said that I would, you can always email me.